Staying with the courts, the United States Supreme Court in a big decision today that impacts a lot of people in the state of Minnesota. The High Court rejected a challenge to the Indian Child Welfare Act. It's a win for Native Americans who were concerned that the Supreme Court would weaken or entirely strike down the law that plays such an important role in maintaining tribal identity. John Croman has more on why this is so important.
Our children are really important to us, just like any other family or any other community. So it is a huge sigh of relief.
Mitchell Hamlin Law School professor Angelique Eaglewoman says it's very significant that in the Howland decision, the High Court upheld the Indian Child Welfare Act by a 7-2 vote, with only Justices Thomas and Alito dissenting.
It is very, very full circle to have Secretary of Interior Deb Haaland, a Laguna Pueblo woman, named on a case that upholds the Indian Child Welfare Act. This is true justice, and this is culturally affirming.
Boarding schools have become the emblem of cultural genocide against Native people in this nation, but even more recently, it was government policy to remove Indigenous children from their families and culture.
And in the 1950s and 60s, the U.S. government funded an Indian adoption project and worked with state social workers to remove tribal children, often on pretextual claims of neglect or poverty or abandonment when a child was visiting a relative.
By upholding ICWA, the court reinforced the sovereignty of tribal nations and made it clear that keeping Native American children in Native homes is a priority.
The Indian Child Welfare Act in the preamble states that Congress acknowledges tribal children are the most important part of our tribal nations. Without our children, we don't exist.
Here at the state capitol, lawmakers were so sure that the High Court would overturn this federal law, they decided to reinforce Minnesota's Indian Family Preservation Act, which is the state's version of ICWA.
Those painful, heartbreaking stories.
Senator Mary Kunesh of New Brighton led the charge in the Senate and welcomed the news that came from the nation's capital today.
It is in the Constitution. It's the right, and the ICWA law ensures that the tribes have a say in what happens to those children and why they are being removed, and the fact that we want to keep them within the culture and within the Native families.
In St. Paul, I'm John Croman.
This was the third time a challenge to the Indian Child Welfare Act has made its way to the U.S. Supreme Court. But our experts told us today that this ruling this morning is going to go a long way towards discouraging any more future legal attacks.